Can't I just add my kids or my grandkids as beneficiaries of my bank account and then they'll get the money? Why do I have to do any estate planning? My name is Philip Bruce. I'm an estate planning attorney in Minnesota. And you do not want, the short answer, you do not want to name minors on any contract. You don't want them to be parties to anything. When you go to your bank account, your IRA, your 401k, your life insurance, and it says where you can add your pay on death beneficiaries. If I die, where does the money go? And you can name people to get that. Those are good for very, very, very straightforward transfers. You don't want to do something like to my child if my child's 18. You can't do that there. To my child or my grandchild if they're 18. To my child, but only if they've died, then it goes to their kids and not to their spouse. You can't do any of that stuff with these very, very basic beneficiary designations. You want to do more planning if you have any thoughts like that, if you have any concerns like that. Those things are very good for, here you go, adult human, here's the money, I'm not worried about you at all, I hope things work out well with this money. So when we're dealing with a minor, the problem is minors can't sign contracts. So if you give a minor money as a pay on death beneficiary of life insurance, IRAs, 401ks, bank accounts, whatever it is, they're going to have that money in their name and they're just not going to be able to access it until they're 18. So first off, if we were hoping to use that for expenses with raising them, for example, probably not going to happen unless we go to court and open up a conservatorship. Even if they have a surviving parent, you're going to have to go to court. That parent's going to have to go to court and be appointed as the guardian for these financial type of things. It's not enough just to be a parent. It will cause a court hearing if we want to access that money under 18. That by itself is problematic. But on top of that, they get all the money when they're 18, and I don't know if that's a good idea. I went to high school with someone who he got $100,000 when he turned 18, and he bought a truck and partied, and then that money was gone in about 2 years. Oftentimes we want to place controls on that. So what we do is within a will document or a revocable trust, we can create some rules, and we can say, we're hanging on to this until you're 25 or 30 or half at 25, half at 30. In the meantime, your trustee, that's the manager of this fund that we've created, can pay for college and they can pay for healthcare. So they can dole out money, but you don't get full control of it until a certain age. Never name minors as pay on death beneficiaries. There's always a better alternative than that. It can create a really big mess. I'll add one more thing. If you name a minor as getting a house, there's just nothing we can do. They're not going to be able to sell the house. Theoretically, you can create some conservatorships, but it's just a disaster. So it's even worse with something that's not liquid. Don't involve minors on legal documents. My name is Philip Bruce, estate planning attorney at Stonear's Law Office. Shoot us an email with any questions.